Okay, let's go.
Hey everybody, and welcome back to my channel, Probation Officer's Perspective. If you're new to the channel, make sure you hit that like and subscribe button, hit that notification bell to all, so you'll be notified of all the new content that I'm pushing out. And I want to thank each and every one of you for your support. Now, as you've seen in the thumbnail, Wes Watson, jury trial, or trial. I just wanted to give you guys an update, like I gave you an update on his bond when he had a hearing for so he could post bond. And I want to kind of put some of the rumors to rest or explain it to you from my perspective. You know, I worked for felony courts as a felony PO. I was an intensive officer, but I know the ins and outs. Like, every state's different. I understand that. But a lot of people are saying he's going to get off on all the charges. The stand your ground law. They didn't show. A lot of people are saying how his criminal history wasn't used against him. And that's because that was in California. And because he was in California, it just doesn't come up. And that's not true. It will come up. You got to understand, he was arrested in the evening, on a Sunday evening, and then he was taken to court in the morning. Normally that's for an arraignment, but it wasn't. It was a bond hearing and a probable cause. And that's what it was about. And some of the players, the judge is not the judge. I showed the court docket, and it says who the judge, who the prosecutor. Normally what they do is one of the judges or several of the judges, depending on how big the city is, whatever judge will take all the arraignments or the bond hearings. You know what I mean? For that morning, the people that have been arrested over the weekend, they'll take the bond hearings. But his original judge is not the female judge that was there. It's a male judge. But we're going to get into all that. And a couple of people have talked about me and this PSI. And I don't even know what the hell he's talking about or what it is. Well, if you've ever been arrested for a felony and sentenced to anything, even if the charges ended up getting dismissed for a technicality or whatever, you have had a pre-sentence that's what PSI stands for, pre-sentence investigation. And it goes through all your criminal history, everything, your whole background, anytime you've ever been arrested, and it shows everything. And then that's how the judge will use that for sentencing purposes. So let's get on with it. I explained that to you, and let me give you the statute on that, because the statute on the pre-sentence investigation for Florida is 921.231. And then that'll explain to you what the pre-sentence investigation process is. I don't know a state that I've ever seen or worked in that didn't have it. But I'm not saying, I haven't been in every state, so some might not. But Florida uses it. The state I worked in used it. And it does a whole background, everything, to see if you're this is the first, you've never been arrested, a first-time felony offender. Or if you have violence on your record because you have a violent offense that you're being charged with. But any prior arrests or convictions, your education background, because let's say that they put, because a lot of people saying that because of the way the situation was, the stand your ground law, and the fact that the guy, even though Wes, he calls everybody out, if they talk shit to him, Wes says, hey, pull up. This is where I'm at. I'm at this gym from this time to this time, 6 days a week or whatever. Pull up. We can catch that fade. Okay. Even though he says that, and there's the stand your ground law. And because the guy came in, set his phone down to record it, he could have recorded it in case some shady shit went down like it did. Or he could have done it for clout. You know what I mean? That, hey, he pulled up on him. There's a lot of different reasons. And nobody knows what those reasons are except for the guy that got put down. But the bottom line is, there's a self-defense and a stand your ground law. But at what, like when you have all these, like he has all his friends there, and I heard people say, well, he didn't tell them. Well, he might have told them. We don't know that. We didn't hear that part. Or they just jumped in on this guy because Wes is their buddy. Like, he didn't need the help. I mean, they weren't fighting, really. They weren't doing anything because Wes really was the instigator in that by hitting him with a weight belt. And then going from there. And, I mean, I'm going to tell you what. As big as Wes is, this just shows you about size. People always say, a lot of people know, but when it comes to that, size does not matter when it comes to, fighting. It doesn't matter. But, as big as he is, talking about, and he's strong, he lifts weights all the time. Same with his friends. They did not knock this guy out. And Wes hit him with the weight belt, punched him like 60 times. His friends hit him with a dumbbell, and he got soccer kicked, but they never knocked him out. Now, did he get some damage done? Yeah, he got a concussion and some, I think his orbital socket was broke or something fractured. Couple black eyes. You know what I mean? But I would say, all in all, for all those big meatheads jumping in, especially Wes, getting all those punches in, he could not knock that guy out. Could knock him out. But that's that just doesn't matter anymore. But I just wanted to explain that to you. So, again, the Florida statute on the pre-sentence investigation, which is PSI is just short for pre-sentence investigation. So when I say that, that's what I mean. It is 921 Florida statute 921.231, and that'll explain it to you better. So let's go to his charges and what's the update on his docket here. And I need to make myself smaller as usual. This never works out like I want it to work out. You know what I mean? And then I've got to look at it down here because for some reason on the screen, you guys can see that, but it's super small and blurry. So this shows his charges. And I know some people at the beginning thought that it was a misdemeanor charge, the aggravated battery, but it's not. So he's got two charges, two felonies. Felony one is the battery aggravated or aggravated battery felony. Charge two was battery felony or felony battery. We call it, like where I'm from, felonious assault, things like that. But they're both felonies. Now, his first charge of the aggravated battery, that carries a max sentence of 15 years. Okay, so it's a felony 2, that aggravated battery. That is a felony 2. So I know some states are felony A, B, C, D. Okay. And other states, which I'm used to, is felony 1, 2, 3, 4, and then 5. Some have 5. Okay. 1 being the harshest felony to 5 being the least. It's basically like a high misdemeanor. It used to be anyway. And like I said, different states are different, but a felony 2 is up there. That's pretty high charge. And then his felony battery is a felony 3. Now, what are they going to do about that? They're going to play let's make a deal, of course. And that's just the way all courts are. He's going to have a pretrial. His attorney's going to be trying to discredit everything. But the problem is Wes's attitude. People, the prosecution is going to, I guarantee you, get so much of the videos and the shit that he talks, the things that he said, the threats that he's made in his videos or whatever it is. It's going to go, the prosecutor's going to have that. Now, that prosecutor that was there, again, just like the judge, was not aware of his case and his criminal record was not, basically, he hasn't lived, he's lived in Florida for a minute, so he's got a Florida driver's license, and they probably ran his Florida record. They had not run him in NCIC to find out. But anyways, that stuff will come out in that pre-sentence investigation. No matter what state you're in, any state you got arrested in, anytime you got arrested, it's going to all come out. You know what I mean? So we'll see if Wes has been telling the truth, which we know he's been half truth on a lot of his arrest or his time that he did and what he did it for. But we'll see, because it will show all that. And what that does is that pre-sentence investigation, it shows that, just look it up. I gave you guys the statute, check it out for yourself. That way you can read it and understand it. But it's used for sentencing purposes. So if they say, we're going to drop, unless his charges, both of them, get dismissed, which I'm sure that's what his attorney's going for. And I'm going to explain to you that in a minute. Even if they reduce it, whatever, and they want to give him probation, that pre-sentence investigation is going to come out. Okay, the judge is going to have it. It's a report for the judge. So he's going to look through there and be like, oh, he's been arrested for this. They want to know about your mental health. If you've been if you have a substance abuse issue or have had a substance abuse issue, your education, do you have your high school diploma, GED? There's just a lot of factors involved in that. So I'm not going to touch any more on that. All right, so let's get rid of this one. And then this is the docket right here. Hopefully you guys can see that. Like I said, I can't see it, so I have to pull it up. So we have all the information as far as what happened on the last video, which was on the 7th. And that was, his appearance is a bond hearing in the morning after he was arrested. He got a $5,000 bond, $2,500 on each count, which is crazy. I've never, $2,500. I've never seen a low bond like that for a felony too. Like I said, felony 1 being the highest. That's a felony 2, and it's $2,500. And then the other charge was $2,500. So a total of $5,000. He got a stay away order from the victim. Now, the arraignment hearing is scheduled for March 7th at 9 a.m. Okay, and that's the last thing you'll see there on. That's the last you're going to see for that day. Now, his attorney waiver. So on the 10th, so yesterday, the docket has arraignment hearings, waiver of arraignment. So his waiver of arraignment, I think, and you can correct me if I'm wrong down in the comments. His waiver of arraignment is he's waiving his arraignment. He does, but he has to plead. His attorney's probably already pled for him not guilty, and in the same time they requested a jury trial, and then it shows notice of appearance and plea. Michael Gottlieb, that's his attorney. And then notice of intent to participate in discovery. So that's where it's going to get hairy. Now, prosecutors and district attorneys, okay, DAs, some people, depending on where you live, it's a prosecutor, others it's a jury, or DA, district attorney. They have investigators, okay? And their investigators go out, or not go out. Well, sometimes they have to go out. And they get all the information. They gather up all the discovery, if they have to. And then they have other people that do it too. But whatever they have in front of them from the police department, the report where this person, pressed charges on him, then they're going to get all the documentation, the discovery, and they have to give that to his attorney so his attorney can, fight back on the case or try to get away with whatever. So, do I see Wes getting these cases dismissed? Like everyone's, a lot of people are saying they're going to get dismissed. He's not going to get anything. He might just get probation, community service. If they were misdemeanor charges, I would say probably, yeah, 100%. But those are two major felonies. A felony 2, that's a major felony. And then he's got a felony 3. The fact that the guy was there with the camera doesn't mean shit. They're going to try, his attorney's going to, of course, that's what the attorneys get paid for, to twist that up, that this was set up, this guy was doing this for a reason. But the fact that Wes did what he did with the weight belt, when the guy like he didn't punch him, he didn't swing on him. I think there was a little tiny baby push, and that was it. And yes, there's a stand your ground, but it's only to a certain extent to neutralize, say, if you're being attacked. You know what I mean? To neutralize that attacker. You have to do whatever you have to do. Well, this guy didn't have any weapons or anything of that nature. Wes could claim he fears for his life, and then he could, they would have to decide that in a jury trial or whatever, whether he was really scared. But then if the videos come out about how tough he talks and he tells people to come there to fight and things like that, it's not going to be good for him. But they're going to do a pretrial, and they're going to play let's make a deal. That's why his attorney he requested jury trial. He pled not guilty. It doesn't say that not guilty, but I'm telling you right now, it's going to be a not guilty and straight. They're pushing for the trial because most of the time they don't want to go to trial. They don't want to spend the money. The state does not want to spend the money on a trial. They are going to play let's make a deal. But that prosecutor is going to want some type of guilty plea. Now, whether it's one of those 2 charges, those felony charges, or they knock it down to a misdemeanor assault or something like that. But remember, all the videos that are going to come out, the fact that his friends jumped in, he's going to say, hey, or his attorney's going to say, hey, I didn't tell them to jump in. You know what I mean? Well, you didn't tell them to stop either. Because after they were doing some work on him, I think the last part of that video, Wes did a huge soccer kick. And that's what I'm saying. So it could go either way. Like I said, it's going to be let's make a deal. And they're always, the good attorneys, or most attorneys are always going to want to they're going to request that trial. Because then that's going to make the prosecution be on their toes, have to have enough evidence to be able to take it to a jury trial and make it worth the time. Are they going to do that? I don't think it's going to make it to trial. Do I think it's going to get dismissed completely? No, I don't think that's going to happen. Even with the stand your ground, like I just explained it to you. He's going to get charged with something. But the other charge is going to get dismissed. He's going to plead to something. That's just my perspective, my opinion. Take it with a grain of salt. Doesn't mean that's what's going to happen, but we'll see. We'll wait and see what happens. But I just want to explain to you guys why that and how everything works so that people understand, like, his criminal history. Dude, it was a bond hearing and they just did it. Now, if he had a California driver's license and he got arrested for that, it would have been a whole different story. Flight risk, you know what I mean? His bond would have been super high because he's not from Florida. But the fact that he's been living there, he's got, I'm sure, a Florida driver's license, Florida resident. We all know he's got a Florida residence. So in that short of a time period, they run him locally, but eventually come jury, if it ever makes it to trial, or if it makes it to whatever, that pre-sentence investigation will come out and his prior criminal history will be used. Period. I'm telling you 100% it will be when it comes down to that. All right, guys, that's what I got for you. Hopefully, let me get myself bigger here. I just wanted to explain that and break it down for you. So he did opt for the trial, not guilty. I'm sure that's normally what you do because that gives your attorney time to get the discovery from the prosecution and go over it, figure out how he's going to twist this all up, and then play ball with the prosecutor. The prosecution and him is going to play ball, and his attorney, is on what is, charges. And is it going to make it to trial? If they have enough evidence that they feel really solid, and that prosecutor, again, was not the prosecutor that was assigned to that case. Just like the judge. Like I said, it was just, they do that. They do all the bond hearings the next day or the arraignments. A certain judge will take that on, or certain judges, and they switch off. Anyways, that's what I got for you guys today. Hope you're having a great day, a blessed day, and we'll see you on the next one. Peace out.